I just know everybody wanted to talk about taxes today. So we are going to address the deductions on your tax return under the new law, specifically the comparison between a standard deduction and the new state and local tax deductions, and whether or not trusts can be useful to take advantage of the new law. Not going to get so much into the numbers thing, but I want to give you an overall view of whether or not that could be useful and what tools may be available to you if you have very high state income tax. I am 𝗛𝗲𝗀𝗻𝘵 of Zammitti Law. We're an estate planning practice in New York and New Jersey, and we provide peace of mind to families through our high client value services. If you are seeking assistance in either the estate planning or administration following a passing, we can assist. We do provide free consultations, and you can reach us at yourplanningattorney.com. And speaking of value, we are also here to educate everyone on a regular basis. So ask questions and share so together we can help some folks along the way. Now, any choices you are ever going to make with regard to mitigating taxes does require quick assessment and weighing of the pros and cons. Often you're not eating your cake, having your cake and eating it too. That's the phrase. There's something that, yes, benefits you, but there's usually a process that's involved with that. So you have to consider both sides. Now, in brief, the new law under Trump's OBBBA, lots of initials, that it increased the SALT cap deduction, right? State and local tax deduction off of your taxes from $10,000 to $40,000 for the next several years through 2029. This is great for those who have especially a higher state income tax, New York being one of them. There is also, and New Jersey is pretty high too. There is also some opportunity to capitalize on this new law by transitioning some assets to what's called a non-grantor trust. And just for definitional purposes, I'll explain. A non-grantor trust is treated like a separate entity and not taxed to you directly. So this means if you have very high taxes, you could get a deduction on your return and of $40,000, right? And a $40,000 income tax deduction on a separate trust return. Sounds pretty awesome, right? But what's the catch? Well, first, you want to make sure you crunch the numbers to see if it makes sense, right? Why are you going to go through all the trouble of setting up a separate trust, having to administer it, if the cost is not much more than the savings, right? And in my opinion, if it's even really close, is it worth all the headache? That might just be me, but you have to weigh those dollars and cents to see if it is worthwhile in your eyes. And don't forget, there's going to come a time in 2030, wow, it's amazing that that's not that far away, where the law is going to change back. And while a properly drafted trust can allow you to sort of toggle between the non-grantor separate entity and grantor tax to you trust, it does take steps and then ongoing maintenance of those separate trusts and or the dissolution of those trusts and moving assets in and out of different titles and names. So running the numbers and seeing whether the administrative process of the in and out, the up and down makes sense for you is important before you jump in. I could probably run numbers, but that would be, I think, better on a one-on-one basis rather than throwing different scenarios out at you. Anyhow, again, I'm 𝗛𝗲𝗀𝗻𝘵 of Zammitti Law. We're an estate planning practice in New York and New Jersey, and we provide peace of mind to families through our high client value services. If you do need some assistance in either the estate planning arena or in the administration after the loss of a loved one, you can reach us for a free consultation at yourplanningattorney.com. We hope you've learned something new here today, and don't forget, please share and take care. Bye-bye.